Okay, let's talk about criminal defense practice and the use of the internet. Let's talk about the clerk's website. We all rely on it. It's a great source of information. Like we were saying earlier about legal research for criminal defense attorneys, the internet is fantastic. Well, it's equally as fantastic if your county's clerk's office has a great website. In South Florida, the clerk's office has really improved their sites in Palm Beach County, in Broward County. They're really something else. Of course, you can do the public search, but law firms get hit with the pay by credit to get case details and whatnot. But cautioning law firms on using the internet or relying on the internet a bit too much and drawing some conclusions. On the clerk's website in West Palm Beach and Broward County, you can do a public search, find out the offense type, the attorney of record. A lot of attorneys use this system to find out if their notice of appearance has been filed. They just check the clerk's website and see if their name's there. Little star next to it in the Fort Lauderdale, in the Broward County Clerk of Court's website. You can find out the judge and your next court date. A lot of law firms use the public search to determine, or at least get some insight as to whether or not they may have missed one. If there's not a date posted, chances are that I don't want to say a warrant would be issued. A lot of the judges have grown kinder to their treatment of defense attorneys and don't really issue capiases if a regular attorney is in front of them. But I can tell you, if a lawyer is unsure of a future date and they don't see it on their docket and check the clerk's website and there's no future dates, I can't tell you how many times I've had a younger lawyer call me up in a complete panic over this. But anyway, moving on. We rely on the internet for everything as lawyers, and that's probably just one step too far. I want to give you an example. We had a 5-year attorney interview with our criminal defense firm. It was a little over a year ago now. And he had talked about how I believe it was the Broward County website was unreliable. A case he was looking for was missing from the system, and it was a drug possession case. I can tell you right now that if somebody comes in to see you and they've been arrested, they've bonded out, and they're not showing up on a South Florida clerk of court website. Of course, you want to check the spelling of the name. Want to make sure you're in the correct county. I've heard stories of too many defense firms filing notices in the wrong county back in the day. And if it's not a traffic infraction, it's going to be on the website. Traffic infractions, from what I understand, take a while to get posted on the clerk of court website, but criminal offenses, misdemeanors, felonies, they are going to be posted. So it's not showing up. You've checked all these things. I would hope you'd know if you were dealing with a traffic infraction, but check the county, check the spelling of the name. You got to ask yourself, is this a drug case? Is this a possession? Is this a simple possession? Did you have a client come into your office, maybe one of the younger associates signed this person up, and figured, well, there's no prior offenses for this individual. This is going to be a diversion case. This is going to be a drug court case, simple case. Let's just get this person in and get them through. They possessed some pills, a bottle of pills. They didn't have a prescription, but it was their friend's bottle. All heard it before as criminal defense attorneys. Well, Prescription medication is the fastest way to turn that diversion case into a trafficking case, as we all know. Prescription medication is the new cocaine, the new heroin. And the bottom line is that clients don't understand all of the nuances if they're users. If they're not traffickers, if they're not people moving drugs in the state, in this country, whether they're moving prescription medications or if they're moving drugs from overseas. If they're just users, they don't know, and that's why they've come to a criminal defense firm. They're scared, and maybe they've heard a little bit about their case because of the amount of pills that they possessed, but they're in a state of disbelief and maybe denial. They don't consider pill imprints. They don't consider crime labs. It hasn't dawned on them that if they possessed a type of prescription medication, whether it's take Oxycontin, and it's not the same milligram, they don't consider if the prescription was filled for generic and what they possessed were the genuine narcotic from the pharmaceutical company. And people charged, users have never heard of aggregate weight in most circumstances, meaning that a handful of pills weighs just enough to put them into a 25-year minimum mandatory range because they possessed 90 Oxycontin that weighed just enough. Now remember, what we started talking about was the clerk's website and a missing file, a missing information about somebody who's been arrested that's come to your office, and it's not showing up. And it's been a week. Well, I can tell you, a light should be going off in your head. Well, was this the type of case that involved prescription medication? Maybe my client wasn't completely forthright with me about the amount of pills. And the bottom line is that you need to consider whether or not this file has been sealed right off the get-go because it's being treated as a trafficking case. These are treated the exact same way as the cases were back in the cocaine cowboy days and the trafficking heroin days. They're sealed from the clerk's computer because traffickers, on the other hand, know about aggregate weight. They know about pill imprints, and they know that people that they deal with, mainly the users, can get arrested for trafficking, even though they're not traffickers. They just possessed the right amount of pills, which really is not that much. It's shocking. But they possess a bottle of pills, they didn't have a prescription, and now they are charged with trafficking. The case is sealed so that that trafficker cannot go on the clerk's website and see if the person they're going to sell to has been arrested for trafficking, because you know what? If somebody's been arrested for trafficking, they're a confidential informant already. Most of the time. You have some clients that are tough as nails. But your average person is going to turn state's evidence against anyone and everyone that they can. They're going to facilitate the making of cases, making of arrests for law enforcement, because it's the only way that they can get out of the minimum mandatory. Very well could be 25 years, day for day, no exceptions whatsoever, with the exception of a youthful offender. If they resolve their case, if they plea for leniency, and they're in that 25-year trafficking range, and I've seen it happen, I mean, with 90 pills and less, aggregate weight of the pill, if they don't provide substantial assistance, they're looking at that kind of time. And the thing is in providing the substantial assistance, they're not given any guarantees. Remember, that goes to the prosecutor. The prosecutor has the final say as to whether or not somebody performs substantial assistance, but we'll have more on that later.